One of the most devastating things for a business owner is to go through the process of hiring and training its work staff only to have an employee turn around and utilize that knowledge and experience for the benefit of a competitor. The most common solution to this issue is having employees sign what's called a non-compete agreement. And these are agreements that will restrict a former employee's ability to do certain things for a certain period of time after their employment ends. And these include things like starting their own business in a similar industry or working in a similar industry or for a competitor. The problem is some courts will not uphold these agreements if they are too restrictive and contrary to public policy. So as a business owner, how can you be sure that your non-compete agreement will be upheld in court? Stay tuned and let's get into it in today's video. Make sure you like and subscribe to our YouTube channel. Hi, I'm attorney Alexis Johnson of AFJ Law Group. And as I said a moment ago, a non-compete agreement can be a great solution to allow you to protect your business's interest. However, the trick is finding a balance. So the non-compete agreement really needs to accomplish two goals. First and foremost, it needs to protect your business. So any trade secrets or proprietary information, obviously it needs to protect that. The second thing is it can't be so restrictive that it interferes with a former employee's ability to make a living. As long as your non-compete agreement accomplishes these two goals, it is likely to be upheld as enforceable in Michigan courts. Michigan courts typically take a case-by-case approach to these agreements, but there are some general factors that they're going to look to for every single agreement, and we'll get into those in a minute. I would just say that if you haven't already had a non-compete agreement prepared, you should definitely reach out to a business attorney so that they can evaluate and draft the agreement to make sure that it is most likely to be held enforceable by Michigan courts and comply with the state law. And even if you already have a non-compete agreement in place, there's no harm in reaching out to your business attorney to have it reevaluated as the laws change over time. I know I've had some of my business clients send me a copy of non-compete agreements that they had previously executed by former attorneys just to make sure that it still complies with the law as it is changing. So it's a good idea to revisit these agreements periodically and to have one in place if you don't already. So when trying to determine if your current non-compete agreement is enforceable, Michigan courts typically look at these four factors, and that is duration, location, line of business, and if it's reasonable. Typically, a non-compete agreement that meets these requirements is going to be held enforceable in Michigan courts. But let's dive a little bit deeper. The first factor is duration, or how long is the employee restricted according to the non-compete agreement. Courts are generally going to look at what's reasonable. But what does that mean in layman's terms? Typically, most courts will find an up to 1 year restriction reasonable. But restrictions that exceed longer than 1 year, such as 2 to 3 or more years, are going to be too restrictive and likely to be shot down in Michigan courts. Next is location, which means that the employee is limited to where they can work in a specific geographical area. And this is going to be a phrase that everyone hates, but lawyers often have to say. It depends, because if your business is large or you're expecting a great expansion in the near future, it could be reasonable to have a large geographic area encompassed in this agreement. But if you have a smaller, more local business, and your agreement is too broad in terms of the geographical limitations, courts are more likely to find those provisions to be unreasonable. Michigan courts will likely find a non-compete agreement to be too restrictive if it doesn't specify the line of business or employment that an employee is restricted from. What I mean by that is, say for example, your employee works in a marketing or design capacity, and the non-compete agreement says that the employee can no longer work in marketing or design regardless of the industry. Most courts are going to find that to be too restrictive and find the agreement to be unenforceable. So you want to make sure that you're very specific, especially if you are in a distinct industry. As I said at the beginning, the whole purpose of a non-compete agreement is to protect your business interests. So you need the agreement to be really clear about what interests it stands to protect. You want to show legitimate business concerns such as trade secrets, client relationships, or confidential or other proprietary information. Basically, you want to show that the purpose of this agreement is for a legitimate business concern and not some sort of punishment for an employee leaving employment. The bottom line is, it's on business owners to make sure the interests of the business are protected. And a non-compete agreement can accomplish that in a meaningful way, so long as it meets the factors discussed in this video and is not too restrictive. It allows a business to continue operations as usual with the security of knowing that your confidential information won't be shared with a competitor, and the freedom for an employee to go on if necessary. It's always important to have a business attorney help you with this process, whether it's evaluating an agreement that you have in place or preparing one for your business. So reach out if you have any questions, afjlawgroup.com. Also, please like and subscribe to this video so that you can continue to see informative legal videos like this one. Thank you for checking out today's video.